What's up, everybody? Welcome back. We have even more details, even more just horrible, despicable accusations being thrown around at Judge Glanville in the YSL RICO trial. And today, Judge Glanville ruled on the multiple motions to recuse him and boot him off this case for the criminal trial and or the contempt proceedings. So we're going to break those down. We're going to look at some motions. We're going to look at some affidavits, and we're going to watch the actual hearing and ruling by the judge that happened this morning, all in today's video. For anybody that's new here, I figured it was a good time to do a very quick introduction of who we are. My name is Peter Tragos. I am an attorney in Clearwater, Florida. My dad, George Tragos, who is joining us for this call, also an attorney. We work together in the same law firm. My dad was a former assistant state attorney and the chief of the criminal division of the U.S. Attorney's Office, a lot of prosecution and criminal defense experience. I have prosecuted cases, defended cases on the criminal side. Now I primarily handle civil trials, personal injury, wrongful death cases. We like to look at these cases, break them down from a lawyer's perspective, talk about what the lawyers are thinking, talk about what the judges are thinking, how it should go, how we think it should go, what's right, what's wrong, all in the interest of justice throughout this process and people learning a little bit more about our judicial system. And this YSL case has been one for the ages because of all of the unusual and wild things that have happened in the case, and really not what's supposed to happen regardless of how you feel about the criminal defendants. And some people may think these criminal defendants are bad. They're, thugs or gangs or RICO or whatever it may be. It doesn't matter. The rules have to be applied to every criminal defendant the same way, and the judge needs to treat criminal defendants a certain way. And that's been an issue throughout this trial. And it's going to be highlighted again here in Mr. Steele, young thug, who's like the main leader, I guess, of this YSL group, allegedly. His attorney, who was thrown in jail, held in contempt in the middle of this trial, has filed a motion to recuse the judge. It's the second recusal motion we have looked at, and it's a lot of the same arguments and standards as was in the first motion to recuse that we read by Mr. Weinstein, who's a lawyer for another judge. There are 6 criminal defendants being tried at the same time. One of the interesting parts were in this, I saw that the Supreme Court of Georgia has granted a writ of cert to address the appeal of the contempt order and has granted undersigned counsel, meaning Mr. Steele, a supersedious bond. So that's something we were talking about, Dad, whether we didn't know whether or not that was going to happen. Anything else you want to point out in this motion specifically before we get to Brian Steele's affidavit, more details about what we now know happened in that secret ex parte hearing with the judge, the state, and witness Mr. Copeland?
Well, I want to point one thing out about that writ of certiorari that you just read. The Georgia Supreme Court actually took this case away from the appellate court. It was originally supposed to be filed in the appellate court. That's the normal way appeals go. The Georgia Supreme Court found that this was so significant and so important, it reached down, which they have the authority to do, granted the writ, and told the appellate court, we're taking the case, and actually took the case out of their hands in order for them to handle it by themselves in the Supreme Court of Georgia. So that's a significant issue because that rarely, if ever, happens.
Yeah, and it's like skipping levels, right? It's like going above your superior's head, basically skipping the Court of Appeals and going to the Supreme Court. But that also shows that that rarely happens, and it shows how important this is and how timely this needs to be with everything that's going on in this case. Anything else from this motion, or is it pretty similar to the last one that we read? It seemed similar to me. There were some additional parts about, sorry, go ahead.
Well, the affidavit, this is a much more aggressive motion than the last one. He says some things in here that are pretty attacking to the judge. He didn't pussyfoot around when he was talking. So as you go through this, we're going to see it's a lot stronger statements that he's making about the judge.
So again, the standards, the judge is going to reiterate when he gives his ruling that we're going to hear in a couple minutes when we listen to that hearing or that ruling. But I do want to read through 2 things that I just found interesting. The first was the order of contempt and the incarceration for Brian Steele. This is Judge Glanville. This is why he held him in contempt and threw him in jail. During the proceedings in the above-styled case on the afternoon of June 10th, 2024, one of the 2 representatives from Jeffrey Williams, who's young thug, Mr. Brian Steele, who's his lead lawyer, took the podium and stated to the court that he had been informed of an ex parte communication which took place in the court's chambers that morning. The only parties present for this ex parte matter were the court's official court reporter, representatives from the state's witness, Mr. Kenneth Copeland, and counsel for Mr. Copeland. In addition to the court's serious concern with how this information was improperly disclosed to defense counsel, Mr. Steele made several claims regarding the sum and substance of the communication that the court found troubling. The court having told Mr. Steele multiple times that he needs to tell the court how he came into the information, and the court having explicitly warned Mr. Steele that he faces contempt of court should he not comply, the court finds Mr. Steele has repeatedly refused to follow the court's order. Every court has the power to compel obedience to its orders and to control the conduct of persons connected with a judicial proceeding. One who disobeys an order or command of the court may be found in criminal contempt. Before a person may be held in contempt for violating a court order, the order should inform him in definite terms as to the duties thereby imposed upon him, and the command must therefore be expressed rather than implied. The question of whether a contempt has occurred is for the trial court, and its determination will be overturned if only there has been a gross abuse of discretion. Once an act has been determined to constitute contempt of court, the action the court takes to deal with the contempt determines whether the contempt is deemed criminal contempt or civil contempt. The distinction between criminal and civil contempt is that criminal contempt imposes unconditional punishment for prior contempt. To preserve the court's authority and to punish disobedience of its orders. So even if he would tell his source at this point, he wouldn't get out, even though that's what the judge kept saying. The judge was just dead wrong on it.
Right.
Direct summary criminal contempt, which arises in the presence of the court and tends to scandalize it and hinder or obstruct the orderly process of the administration of justice, the preservation of order and decorum in the court, etc., is exempt from the due process requirements of notice and hearing. Accordingly, it is hereby ordered that pursuant to the court's authority under that rule, the court holds Mr. Steele in direct criminal contempt for failure to comply with the court's order. It's further ordered Mr. Steele shall be taken into custody of the Fulton County Sheriff and incarcerated at the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. Mr. Steele is to report to the Fulton County Jail. That's the address, and will be released on 7 p.m. on Sundays. He'll get there 7 p.m. on Fridays. And it'll start June 14th and not end until August 18th. That is the court's order. What do you think?
Well, I mean, he did as good a job as he could do to justify what he did. And, that again, that order is not unique. Most of the language in that order is pretty standard of any contempt order.
What's funny is he defined contempt correctly and all this stuff and had all the rules right in his order, but on the spot when they were talking about it with the lawyers in the courtroom, not so clean, not so nice, not making quite as much sense because he was kind of wrong on some of the things. So I thought it was interesting. He cleaned all that up, which is what lawyers do, right? We go research, we get the answer, and then we write it into a motion. It's not a pop quiz. It's not a closed book test for us.
No, he was dead wrong, and the lawyers there explained it to him.
All right, so let's get into the joint affidavit of Brian Steele and Keith Adams. We are over the age of 18. We're counsel for Jeffrey Williams. Monday, June 10th, affiance learned the following events and the fact occurred outside of Mr. Williams' presence and outside the affiance presence. Do you say affiance or affiance?
Affiant.
Affiant. Affiant presence and in a star chamber-like environment. Here we go. So here's the big one. And when we listen to the hearing, they reference paragraph 4 multiple times. So this is paragraph.
Also, don't forget the language he's using. Star chamber. It starts right from there making those accusations. Those aren't nice words. And he's starting right off using those words.
And this is the paragraph that he references. He says, Judge, at least look again at this as we discuss it. So this is what he's referencing. On Monday, June 10th, 2024, undersigned affiants, specifically Brian Steele, asked to have a transcript of whatever conversations were memorialized, and affiants requested the actual recording of anything discussed at this improper in-chambers meeting on said date. This court has obstructed Mr. Williams, who's the defendant, and below affiants from having an exact image of what was said. This obstruction alone shows that this court is biased, as there is absolutely no privilege in communications in this court's chambers, as this court argued on June 10th, 2024, and there is certainly no attorney-client privilege under any stretch of the imagination, as this court has asserted. Did you want to say something?
Yes.
Go ahead.
Yeah, key words, obstruction and bias. So he's coming right out and accusing the judge of being biased and obstructing.
This obstructionist conduct by this court shows bias, and that this court is intrinsically intertwined in the facts of this case and has prevented Mr. Williams from due process, fair trial, effective assistance of counsel, right to know every material and critical happenings in his case. And those are all more rights of the defendant that are the most important things, basically, when you have a criminal case in a trial: due process, fair trial, and effective assistance of counsel. Further, this court's by its words used on the record when speaking in open court with affiant, as well as the court's silence, as well as lawyer Love's statements in open court, clearly demonstrate that the facts below are true and accurate. So this is an interesting thing. Throughout the process, a lot of things have been said. In the ruling today, when we get the judge's ruling here in a minute, a lot of things are said, but you know what is not said? That that's not true, that you guys are lying, that that's not what happened. Nobody ever says that.
Yeah, and again, we'll hear the judge later. This is a fact. These aren't opinions. These are actual facts that he's putting in here, even though they're characterized later as opinions.
Well, not just that, but they're supposed to be taken as true.
Right.
According to the case law and how you look at this, a lot of things, it's like a complaint. If you file a civil complaint, everything I write in there, if the judge is going to rule on a motion to dismiss, he has to assume or she has to assume that those facts are true. And if they are true, can I prove a claim?
But the judge is saying these aren't facts, which is hooey. But he is saying these aren't facts.
And that's why the distinction, because if they're facts, he has to take them as true.
Right.
And if he takes them as true, then they would rise to the level that something must happen that he doesn't want to happen, which we'll talk about later. The court has also silenced witnesses improperly, issuing a show cause order for contempt and thus making all witnesses in fear of going to jail if the truth is told about this improper violation of Mr. Williams' constitutional right to be present at every critical stage of his trial. Fair trial, fair tribunal, effective assistance of counsel, due process under the law, the right to make a record in the case. This court is biased and must be recused. Further, the cross-examination of Mr. Copeland will include facts that occurred at this Star Chamber meeting, which puts the credibility of lawyer Love, lawyer Hilton, this court in issue, and this court should never be the person who is in charge of the jury when the court's conduct is being questioned, based upon the courts and lawyers for the state of Georgia's actions. Mr. Williams has been put into a trick box by the misconduct of lawyer Love, lawyer Hilton, and this court, accusing them of misconduct. He is holding back no words, pulling no punches. This court must be recused, a mistrial declared, barred by double jeopardy based upon prosecutorial misconduct and judicial misconduct. That's paragraph 4. That's the one everybody should remember when we get to the actual hearing. Mr. Copeland is a witness who has been called by the state and sworn on Friday, June 7th, who invoked his Fifth Amendment and was held in civil contempt by this court, which civil contempt is different because they want this guy to testify. So they're going to hold him in jail in civil contempt until he does what the court wants, which is testify in this case. That's civil contempt versus criminal contempt, punishing bad actions in the courtroom, not following a court's order. Unbeknownst to affiants, Mr. Williams or anyone else on the defense side of this case, this court met in chambers with Mr. Copeland, his counsel, lawyer Love, and lawyer Hilton, and at times court reporter Weaver, as well as sheriff, deputies, and other persons. Deputies may have been instructed to turn off their body cameras. Interesting. There was and is nothing privileged under the law about this improper ex parte meeting. Do you agree with that?
Yes,
I agree.
Again, we don't see any national security concerns.
And it's not like talking to the judge is privilege. It's actually like the opposite of privilege. Like everybody should know what everybody's saying to the judge. This court and the others met with Mr. Copeland for a lengthy period of time. The total ex parte meeting lasted for more than 1 hour, approximately 2 hours, with the above named people at the meeting at all or various times. Mr. Copeland continued to make known his assertion that he would not testify, even if in the face of being held in contempt and ordered to testify under use of immunity. This court and lawyer for the Fulton County District Attorney's Office, Love and or Hilton, ignored Mr. Copeland's decision and continued to declare to Mr. Copeland that he would be held in custody until he testifies, or alternatively, if he persists in refusing to testify, he would be held in custody until not only Mr. Williams' current trial resolves, but until all 26 indicted persons' cases are resolved, whichever is longer. This court was a participant and was present during the admonitions/threats to Mr. Copeland. This is witness intimidation, coercion, and the court has become a member of the prosecution team in assisting the prosecution to induce a material witness to testify. It's exactly what we said when we discussed it initially.
Now, again, think about how strong that is. He is now accusing the judge of being part of the prosecution team. I mean, that's about as strong as you can get.
This court, lawyers Hilton and Love, are now all witnesses in this case and will be called by Mr. Williams and or possibly other accused so the jury can determine demeanor and credibility of what occurred at this in-chamber meeting. Please note that the witness list is hereby amended by this joint affidavit to include the court, lawyers Love and Hilton, and all other relevant material persons that have information to share with the jury regarding the conduct, words, and actions at this ex parte communication. Woof. The amended witness list. This court provided Mr. Copeland with a written copy of the statute of crimes of perjury as well as false swearing. This is no subtle gesture and one that helped the prosecution team obtain their mission for Mr. Copeland to change his mind and testify, because we know he is currently testifying / they're listening to impeachment tapes. Lawyer Love made representations to this court in front of Mr. Copeland and his counsel, sheriff deputies, the court reporter, and others that Jonathan Melnick, Esquire, counsel for Mr. Copeland, committed misconduct during his representation of Mr. Copeland and was not representing the interests of Mr. Copeland. We watched that hearing together. It's on the prior video. These are knowing misrepresentations by Lawyer Love to this court, which Lawyer Love continues to do, which biases this court in favor of the state and against the accused, their lawyers, and other members of the bar. Further, the court permitting Lawyer Love to speak ill of Mr. Copeland's counsel in front of Mr. Copeland adds to the coercion and witness intimidation. This ex parte discussion violated Mr. Williams' constitutional right pursuant to Article 1, Section 1, the Georgia Constitution, to be present at every material stage of this trial. The court and Lawyer Love and Hilton speaking with Mr. Copeland and sworn witness about his testimony, whether he would change his mind to testify, is clearly a critical stage of the proceedings. As asserted in her motion to recuse, this court filed at 10:40 p.m. Attorney Bumpus, okay, which is now the attorney that was standing in for Copeland at the ex parte hearing, verified the below facts. These facts are adopted into affiant's affidavit as below. So now, to me, this feels like Steele is revealing how he got his information. He doesn't come out and say it, but that's what it sounds like here. That Attorney Bumpus, who was stand-in counsel basically for Mr. Copeland in that ex parte hearing or meeting, is the one that revealed this information to defense attorneys. Doesn't feel like it's 100% confirmed, but it certainly feels like it's going in that direction. Would you agree?
Yes, and Attorney Bumpus had a lawyer in the courtroom today representing her, and he also filed a motion to recuse.
Correct. Yeah, and we'll hear a little bit of that.
Right.
On Monday, June 10th at approximately 8:30, Mr. Copeland and his lawyer, Attorney Kayla Bumpus, were escorted to the court's chambers and conducted an ex parte meeting regarding whether Mr. Copeland would testify. By the way, this is as scary as it gets for Glanville because he knows the cat's out of the bag. And if she was there, all the details are coming out, whether he likes it or not. And we'll come back to that when we watch the hearing. Those present for the substantive portion of the ex parte meeting were Judge Glanville, Copeland, Bumpus, Love, and Hilton, members of the court's security staff and deputies, 2 investigators from the Fulton County District Attorney's Office, and the court reporter. So basically the entire prosecution team and investigators, and then Mr. Copeland and his lawyer. In chambers, this court asked Mr. Copeland whether he was prepared to testify. Copeland announced he planned to invoke the Fifth. A conversation among the parties ensued regarding Mr. Copeland's understanding of immunity, how Mr. Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. So she didn't necessarily say specifically what he said. So she didn't reveal attorney-client privilege. Once Mr. Copeland learned that he could be held indefinitely by the court, he refused to testify, not just 2 years as he initially believed. Mr. Copeland decided that he would testify. He added that his testimony would be a lie. The meeting ended and the parties went to the courtroom. So a little less detailed than the last affidavit where it talked about, we're not going to prosecute you if you lie. We will prosecute you if you testify to this. So a little bit different, a little less detail there than the last one. So what's the truth? Who knows? This court never assured that this Brady evidence would be revealed to Mr. Williams or his counsel, and Brady evidence includes the fact that this meeting occurred. Instead, this court takes the position that no information about this meeting should have been revealed to Mr. Williams, his counsel, or anyone outside of the Star Chamber where same occurred. This shows that the court has become a member of the prosecution team in an effort to thwart Mr. Williams' constitutional right to a fair trial and a fair tribunal and due process and right to be present for each critical stage of the proceeding, right to call witnesses, right to present a defense, right to cross-examine on critical topics, including the facts of the case that were discussed with the court during the intimidation of the witness. This court must be recused. The court and the prosecution have violated Mr. Williams' rights, and the indictment must be dismissed after mistrial is declared in the court, and the state has goaded Mr. Williams into moving for this mistrial recusal of the court. So it's a mistrial at the fault of the prosecution, which is why double jeopardy should attach, and he should be let go, basically, is what the defense is asking. It's probably a bit far, but it's where we are.
It's a legitimate argument, though. There's case law that does back that up.
Mm-hmm.
So it is. I mean, I'd make the same argument. That's legitimate. This is a deliberate attempt by the prosecution to mess the case up. and therefore they should be charged with the mistrial, and therefore it's double jeopardy.
You'd expect to lose that, though, I think.
Yeah, I would expect to lose it, but I certainly would make the argument.
Sure, and I think it is a good argument. Monday, June 10th, approximately 1, once affiants made the above known in open court, the court refused to release the transcript of this improper ex parte occurrence, held Mr. Williams' lawyer in contempt of court, ordered Mr. Williams' lawyer to serve the maximum time in custody in an attempt to intimidate Mr. Williams and his counsel from understanding and learning about the courts and the prosecution's wrongdoing. So that's a good point too, is like he tried all this stuff to strong arm them into just going away quietly and not keep pushing the judge on this issue. Absolutely using his power, in my opinion, to coerce them to do what he wanted to do, not what's best for Mr. Williams in protecting his rights. The court has become a material witness because undersigned counsel has the right for the jury to understand that this court met with Copeland and the prosecutors in order to convince Mr. Copeland to testify against Mr. Williams. Ex parte meeting on June 10th with a sworn witness concerning the witness's willingness or non-willingness to testify, and this court giving the witness a copy of the law of perjury and false statements and discussing the facts of the case is unforgivable. This is not an ex parte meeting that the court has had with affiants ever. On the very few occasions that the affiants have had an ex parte hearing with this court, affiants announced in open court that it needed to speak with the court ex parte. There was no objection by the prosecution and same occurred. Never was a witness involved in these rare ex parte meetings. Affiants demand to question this court and the above lawyers for the district attorney's office as to how many ex parte hearings they have had. That's a good point. The substance of those meetings, who was represented at, and the like. Even if just one ex parte meeting occurred, as it did on June 10th, this mandates the court has forfeited its role as an impartial judge and has become a member of prosecution team. Court must recuse itself. The court, on at least one occasion, has been fed improper ex parte information about facts in this case and a witness statement about his refusal to testify. The court met with the witness and spoke with the witness about the witness's willingness or non-willingness to testify along with the prosecution, and then held undersigned counsel in contempt when undersigned counsel simply wanted to know why he was not notified of this ex parte judicially and ethically prohibited meeting. More shots taken. The court has now placed the lawyer for Mr. Copeland and other unknown persons in a position that they need to come before the court on a date certain to give testimony as to who gave information to affiants concerning the improper Star Chamber meeting with Copeland, the prosecutors, the court. Court has become the executive branch conducting an investigation as a grand juror / prosecutor. This court has lost all impartiality, and Mr. Williams cannot receive a fair trial with the court being present over the proceedings. This court has falsely and wrongly accused affiant, specifically Brian Seal, of being unprofessional and unprepared in front of the jury. We've done some videos on those clips. If you guys want to see them, you can check out our playlist on the YouTube page. If you subscribe, you'll be able to see those. Neither claim was close to the truth or was accurate. The prosecutor sat silent as affiant was wrongfully and falsely accused of improper conduct. This court has violated every neutrality, impartiality that it was sworn to undertake. Even knowing that the court has falsely accused Brian Seal of being unprofessional and unprepared in front of the jury, the court has refused to instruct the jury to disregard the court's improper comments. This clearly shows that this court is biased and impartial against Mr. Williams and or his counsel and in favor of the state, and as no fair judge would not correct such a serious misstatement made in front of the jury. The bias of this court is objectively proven. When Mr. Copeland took the witness stand on Friday, June 7th, he refused to testify and was taken into custody. The court knew, so he's accusing the court of knowing and improperly allowing him to take the stand and plead the fifth, which is pretty wild. And as did the prosecution, that Copeland would refuse to testify in front of the jury, but the court did not reveal that fact or take any action to stop Mr. Copeland's refusal to testify in front of the jury. Mr. Copeland's refusal to testify in front of the jury prejudiced Mr. Williams a great deal, and the jury should never have heard Mr. Copeland exercise his Fifth Amendment right. This court told the courtroom deputies to prohibit the media from filming Mr. Copeland when the court ordered him to be arrested. This direction occurred before Mr. Copeland even took the witness stand. Ooh, how are they getting that information? Sounds like from the deputies, right?
I know. And deputies do talk. I mean, if they like the lawyers, they'll talk to the lawyers.
And if they see it being this bad, and a lot of them respect lawyers, a lot of lawyers were former prosecutors, some were even former judges, and they don't like judges going off the rails either.
No.
The court has harmed Mr. Williams by hiding this information from Mr. Williams, having ex parte communications with the deputy and media, and permitting Mr. Copeland to assert his Fifth Amendment right in front of the jury. When the Honorable David Botts, Esquire, brought to the court's attention that he had evidence that the prosecution knew that Mr. Copeland was going to invoke his Fifth Amendment right in front of the jury, this court refused to have a hearing to determine whether the prosecution knew that this witness would invoke his right to remain silent or refuse to testify. And instead, the court had a problem with Attorney Botts. This is backwards. The court has shown bias against Mr. Williams and his lawyer in favor of the prosecution. Court must be removed from further dealings. Mistrial based on goading improper conduct, double jeopardy again. Okay. So I think that was about like somebody told the prosecution in the hallway, or they knew that he was going to plead the fifth and they still put him up there. And then they said they didn't know. In sum, the court must be recused and or trial be declared a mistrial based upon the improper judicial prosecutorial conduct that includes, but not limited to, the court, lawyers Love and Hilton are now witnesses because they helped Mr. Copeland change his mind and testify by coercion. The court ex parte assisted the prosecution team by convincing Copeland to change his mind and testify. The court has obstructed justice by ordering any transcript of ex parte meeting not to be produced to affiants to use to particularize this affidavit, as well as to cross-examine Mr. Copeland, the court, the lawyers for the state, and others before the jury. The facts of the case were discussed with the court at this impermissible ex parte meeting, and Brady evidence was not revealed to affiants by the court and or the lawyers by the state or for the state. Mr. Williams has questions for Mr. Copeland, the court, lawyers for the state, and others about improper ex parte meeting, how same occurred, who discussed the fact that this secret meeting would occur, and the substance of this meeting to the jury. So the jury can decide whether the court and the state have colluded against Mr. Williams. Whew, that was a lot to read. So anything else you want to highlight or talk about before we get to the hearing and the judge's actual decision?
You said it, and people need to realize how important it is. He did not mention those statements about we won't prosecute you for perjury. That's really important and a real distinction between these two affidavits. Why did that one lawyer have information about that ex parte meeting that Mr. Steele did not?
Well,
and how did he get it?
So this happened after the last one. So maybe more information has come out, like maybe that's not true. Maybe Bumpus said that didn't happen and somebody did tell the other lawyer. I don't know the answer, obviously, but that is interesting because it's a pretty big fact. It's a pretty bad fact.
It's a huge fact because it theoretically happened in front of the judge as well.
Exactly. All right. So we are going to jump in now to the judge hearing these motions.
Or disqualify the court. Recusal by a Superior Court judge is governed by Uniform Superior Court Rule 25, etc. Rule 25.1 provides that all motions to recuse and disqualify a judge presiding a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which shall set fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for the disqualification, and not later than 10 days prior to a hearing or trial, which is the subject of the recusal or disqualification, unless good cause be shown for the failure to meet such time requirements. And that is cited in Georgia Uniform Superior Court Rule 25.1. So I'm applying that to both sets of motions to recuse. And applying this rule, Georgia courts have held that when a motion to recuse is filed, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit, and 3, the legal sufficiency of the grounds, and has no power to do anything else. And that is Robinson versus the state.
So he's just laying the foundation of the standards and what he can and can't do. Hold on. I just, let me know if you're going to just put your finger up or whatever, because I'm going to mute so we don't hear. I got you now. Go ahead.
Okay. Keep in mind, he doesn't have to read the entire statute. He's doing that for the cameras.
Or the record. I also think he's trying to make sure this record is nice and long. And just wait, when he makes his actual decision, he looks for the specific verbiage that is in the cases that he read in order that the record shows the specific verbiage on the reason why he didn't let this go to another judge.
332 Georgia Appeals at 240-241. The 3 threshold determinations that the trial judge must make in regard to a motion to recuse are whether it's timely filed, whether the affidavit made in support is legally sufficient, and whether some or all the facts set forth in the affidavit, if are true, recusal would be warranted, and that is Dacker versus the state, 300 Georgia, 74 at 77, 2016. The judge finds any three of the conditions have been met. No, I'm sorry, take that back, strike that. If the judge finds that all three conditions have been met, he must refer the motion to another judge to hear the motion. But if any one of the conditions is not met, there is no error in denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion. Accordingly, the court is going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was in fact filed on this past Monday, which would have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed, as it was filed on the filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit, that means, was it sworn? Was it sworn before a notary? Is in proper form? I find Mr. Williams and Ms. Bumpus's motions to be, or I should say affidavits, to be in proper form. The third thing that the court has to review, and like I said,
So those first two are procedural. He's saying, all good, you guys did all the procedural stuff right. But now let's get into the big question, which is part 3.
I reviewed is the legal sufficiency of your grounds of the motion. And
so look, he looks back at the specific either case law or statute to get the verbiage he wants.
And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions, which
Bare assertions and legal conclusions. That's what you were talking about before. I unmuted you, but that's what you were talking about before, that he was going to make sure that that's what they were called, bare assertions and legal conclusions, not facts, but
they were facts. I mean, they are absolute cold facts, and they had a basis for the factual allegations. His ruling is really off the wall.
It's not off the wall. It's exactly what you'd expect. Judges abusing their power. I mean, if a judge has discretion and they want to abuse it, this is what it looks like. It's like he technically can do this and keep it out of the hands of any other judge or anybody else looking at it. He can kick the can down the road. He loves telling them to appeal it. He loves saying the appellate courts will look at it. The appellate courts will make their decision. And again, some people, just lay people watching this and listening to this, might be like, okay, good, they're going to go in their appeal. Appeals are really hard. They take forever. Something like this probably will get overturned, but a lot of times, it's a very small percentage of appeals are successful, and appeals are for losers. So you already lost something if you have to appeal it. So for him to just say, go appeal it, that's not how you're not supposed to try to get it wrong the second time, because the appellate court is there to fix your problem.
And remember, he said what the standard was: abuse of discretion. Trial judges have a lot of discretion. The appellate courts don't want to sit there and retry the case. They're just going to take a look at the record. All right, he has discretion. He has to actually abuse that discretion, which I think he has. But that's a high standard. And that's why he knows, take it to the appellate court, because the appellate court, I got a shot of winning. And he knows it.
Exactly. It's especially like you start off the winner, and then they've got to determine to be like, nope, actually, you didn't just win, you lost. And that's hard to do.
aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to.
So if he would not have found that they were bare accusations and legal conclusions, if he would have found the answer to that was that's not what it was, but these were facts, if taken as true was a problem, then another judge would have to look at it and determine if he was supposed to be recused, right?
Right. And we finally get a hearing. That's what he's avoided this whole time, is giving this thing a full hearing. He's avoided that. He's got a transcript. I mean, this really could be solved by him spending some time giving it a full hearing and a full airing. But instead, he's fighting it every step of the way.
Right. He's using his power to
Right.
not allow the process to happen.
Right. And shutting the lawyers up.
To deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made, doesn't mean that the court stops the trial. So
he's basically saying you guys are only asking to recuse me because adverse rulings have been made. It's like we've seen a lot more than adverse rulings in this trial. Come on.
I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only three things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time.
Literally kicking the can. He's like, all I have to do is read it. We don't have to argue about the facts. You don't have to mention them again in open court. We don't have to get into any details. I did what I had to do. Let's move on. Basically, that's what he's doing. Anything?
No, you're right. I'm just waiting because there's some interesting stuff still happening.
Yeah.
You all take it up. No, I won't grant a motion for a certificate for immediate review. And that's where we are at this point in time. Anything else, Mr. Banks?
If I could just briefly be heard, Judge.
Sure.
And I'm not trying to, I understand the court's ruling and we'll proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal,
Sure.
it can certainly be, I mean, the appellate court will review my ruling for abuse of discretion.
Certainly
Okay.
understand that, Judge. And
This is like the definition of abuse of discretion.
in stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding. And so because you were a witness.
I don't believe you. Well, I'm not going to get into any argument, but I can't. So that's your assertion at this point in time. And like I said, when that is taken up, I'll consider. I also remember I still need to rule on the issue of the motion to quash. So I may, depending upon what I decide to do at that point in time,
Sure.
Other things may be ripe. Okay.
Do you want to hear about the motion to quash, or you want to take?
No, not yet, sir. I'm going to take up the motion to quash after I finish. We finish the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here, there is a transcript of what occurred in the ex parte matter. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and or Brady.
So he's going to turn over the transcript of the ex parte meeting. Sounds great, right? Especially that's because what Steele and them were all asking for. Except he's going to remove anything that's privileged, and he's only going to turn over Brady and impeachment material. Right. Who's going to determine what's Brady impeachment material? That's the annoying part, because usually lawyers like to argue that something is or is not Brady or impeachment or why they should be able to use certain things, he's not even going to give them the opportunity. He is going to strike certain parts and say that's either privileged, not Brady, or not impeachment. Therefore, for taking it out of the lawyer's hand altogether and taking it out of the lawyer's hands for the ability to even prepare a record.
Well, see, the one thing you have theoretically in a trial is a neutral judge. And the prosecution is going to present their argument about what should or shouldn't be turned over. The defense presents their argument about what should or shouldn't be turned over. Then the judge, as the neutral, makes a decision about what should or shouldn't be turned over. In this case, the judge is your adversary. And that's what they're talking about his bias and his obstructionism. He's the adversary here. He's in partnership with the prosecution on this. And therefore, you don't have the level playing field you try to have in a trial, and you don't have a neutral judge.
And if you look at some of the other cases, like we'll just say Johnny Depp and Amber Heard, you remember those parts where Amber Heard's lawyers were reading all these things into the record that the judge wasn't letting in. The purpose of that is the appellate court to say, this is what they wanted to get in. This was the argument. This was the other side's argument. And here's the judge's ruling. Imagine not being able to look at the documents you want to get in. That's what this judge is doing. He's not even letting the lawyers look at the documents, draft an argument as to why those documents should come in or those statements or whatever should come in. He is removing the ability to even look at potential evidence and make an argument on the record as to why it should be there. He can obviously say, no, it's not coming in, but to not even allow them to make a record of that, I mean, that's wild. I would assume they would be able to attach the unredacted ex parte transcript to the appellate.
Right. It'll be sealed.
Right.
Sent to the appellate. But here's what, it's easy to say this. Here's what the judge should have done.
Right.
What the judge should have done is he should have called the lawyers, just the lawyers, into chambers. And he should have said, okay, I'm handing out the transcripts to the lawyers. You guys can take a look at the transcripts and tell me what it is you want to come in and don't want to come in. We'll have a hearing on it. He could do it in camera. He could do it so that the public doesn't see it till later on. But at least give the lawyers the opportunity to make arguments about what should or shouldn't come in, because why not? Why not let the defense lawyers read that transcript? What could there possibly be in that transcript that the defense lawyers can't see? Maybe they can't use it in trial. They can make that argument, but what is it they can't see? I mean, what possibly could there be? I can't even imagine something that they can't see that's in that transcript.
That would be privileged, that the prosecutors could see, that random bailiffs could see, that the judge could see, but it's privileged. That makes no sense.
No, none.
And for that, and I will do that. And then so if that pertains or if that issue affects you, then certainly that may be something that at the appropriate time, you'll be able to have a look at.
Well, I appreciate the court's time. We would certainly rely upon our brief and our motion, and that's a part of the record. Okay. All right. But I will reach out. The court will reach out to you on two things. One, the ability to take a look at the ex parte transcript and review it for the appropriate parts that the court will authorize. And then also for
he keeps saying, I'll let you review the transcript for the appropriate parts the court authorizes.
I'll re-notice you because I know that it's supposed to be done this Tuesday, but I doubt that we'll probably have it this coming Tuesday. If I just may say again, Judge, I know I've already said it as it concerns the issue about you being a witness to the proceeding. We don't believe that that's a bare allegation. We believe that would be an established fact at the hearing. We also, but I can't take it. It's not something that I can argue with you at this point in time. I'm not trying to argue. No, sir. You are an advocate for your client. Sure. That's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel. You made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling.
And this judge has also created a courtroom where the lawyers do a bit feel like they have to walk on eggshells because they could be thrown in jail at any moment for contempt. Now, the response to Steele's doing that is like, what a great criminal defense attorney. But if you're just a random person showing up for a hearing in front of this judge, he has created an atmosphere now that's pretty toxic in the courtroom.
said what you needed to say.
What were you going to say?
Oh, I was just going to say, however, the flip side of that is if he starts throwing other lawyers in jail, the appellate court is going to just throw this case out so
Sure.
fast and try it again. I mean, how many lawyers can you, how many lawyers can you do it to? Yeah.
Sure.
In terms of what your thoughts are, I'm going to reduce it to an order, and you can take what you want to after that. Okay.
All right, thank you.
All right. Thank you, sir. All right. Mr. Steele, similarly, I'll reduce what I've mentioned to in an order, and you will be able to take it up as you see fit. I'm not going to grant a motion to a certificate of immediate review. Anything else?
I have read Baptiste versus State. I've read all the cases that I believe are applicable. I'm, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting ex parte with the court and others and the prosecutor and a witness, and specifically they wrote in a pleading and under Parish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022. The lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I've added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't.
You want to talk about how problematic that is?
Yes, that's a wonderful argument. It's the logical argument. I'm going to be talking about impropriety on behalf of the court. Yet jurors always love judges because they think judges are the authority in the courtroom and the neutral in the courtroom. So no matter how much you try to impeach that witness based on the judge at the end is going to look at them and say, I'm going to instruct you on the law. This is my courtroom. I'm king, and you can believe that I won't do anything wrong. And jurors believe that.
And not just that, but the judge is also going to read specific instructions like the credibility of witnesses. Right. And if the judge thinks they're credible, and if the judge did anything, the judge was obviously playing by the rules because he's the one that tells us what the law is. So if he tells us what the law is, of course, he's going to do with what's within the law. That's horribly problematic.
It is.
Imagine how that's fair to Mr. Williams. So I just asked you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I asked the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
So I said paragraph 4. I was wrong. It's paragraph 12. It's the one with the attorney bumpus stuff, which we read, but that's the one he kept reiterating, not 4.
Also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand
I'm not going to, Mr. Steele, I can't argue with you about anything such as I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that,
You would still say that they were bare allegations and legal conclusions. Like, let's be honest, he's not going to take anything seriously. And he's just hiding behind the, oh, we can't argue about this now that I've made my ruling.
you're going to have to put those in some other pleading. But at this point, Miss Weaver is going to prepare the record. She does that. And like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything
Wow, what a guy.
that you have at that point in time.
Yeah.
It's really sad when you think about it. Miss Love's not in the courtroom today, I notice. But it's really sad that he's going to make these redactions in that transcript and turn over the defense. The only people that can object to the redactions, the only people that can talk to the court about the redactions is the prosecutor. Because maybe the prosecutor doesn't want some stuff in. And so I doubt very much that the prosecutor is going to say, oh, no, judge, give them more. Instead, the prosecutor is going to say, give them less. And they have an argument. The defense lawyers have to kind of just sit there like, with their hands folded because they got nothing to argue. That courtroom is so tilted that it's such an unfair situation. And this, more of a shame, odds are they're going to try to do a writ of cert to the Supreme Court. Since the Georgia Supreme Court seems to already have taken an interest in this case, they might take an interest in this. So they're going to try to do something, even though the judge did not certify it up. They're going to try to do something because the Supreme Court of Georgia has the discretion to take things up. So they're going to try to do that. But another shame is these lawyers have been in trial for 7-8 months.
Mm-hmm.
How horrible to have this case reversed.
I would be so depressed after all this work and time.
And have to try this case again.
But they've been in trial 7-8 months, but they started picking the jury, I think, even 7-8 months before that.
I mean, gosh, having to try this case again. I mean, that is just, you're right. You'd be really depressed. I mean, it just, because your life, whenever you're in trial, and I know, I've been in trial there this long, your home life, your life is on hold because everything revolves around the trial. And especially a trial like this that has so many complications and twists and turns. When they go home every night, there's another thing, another motion, another appeal to write. In fact, I heard today that the appellate lawyer for Mr. Steele is his wife. Apparently she's an excellent lawyer. And so she did all the appellate work when they appealed to the Georgia Supreme Court. Was actually Mr. Steele's wife.
That's pretty cool.
Yeah. But just think about, what they're home. They must have papers scattered all over the dining room. I mean, you can just see it now. All the research, they're up all night doing research. I mean, that house must be just 6 months worth of chaos.
Thank you.
All right. Okay. All right. Let's turn now to the statements or interviews from January.
All right. So that was it. That was the last part of the hearing that we were going to watch because then they start talking about Copeland and that kind of stuff. So yeah, overarching theme is it's just totally unfair. It feels like an abuse of discretion. Are you drumming something? Oh, I could hear a do. I think it might be next door or something. But so anyways, yeah, I mean, from my perspective, totally unfair. What do you think is going to happen?
Well, I think they are going to fashion some kind of a writ of cert to the Georgia Supreme Court. I don't know. I just got to believe that the Georgia Supreme Court is going to say, we've got to take a look at this. Otherwise, why let them finish this trial just to let them try it again? So if this is wrong, let's nip it in the bud now. If it's not wrong, then let's nip it in the bud now so that we can finish this trial. Because it's just such a waste of everybody's resources and time to try this case again. They've got to look at judicial efficiency, and the world is watching. it doesn't escape appellate judges that the world is watching particular trials or particular issues, and they want to make sure that they get it right. So there's a good chance they might accept a writ on this.
It's a good thing the world is watching, because imagine if this was you, imagine if this was your family member or loved one. I mean, it's just not the way it's supposed to be.
No, it's not.
All right.
And Steele is, and I've got to tell you, and I'm this way, so I understand. Steele is a very together guy. He doesn't lose his temper. He doesn't yell and scream. He's calm, and regardless of what the judge does, he has this leveled demeanor. That's what you have to have, and I give him credit for that, because a lot of lawyers would have lost it on this judge, and that would have just not been any good and would have benefited no one.
Right. Yeah, and it would have frankly made the judge look good and the lawyers look bad, and looks like that's why the judge did it. So, all right, that's all we got for this one. Thanks for joining us. Let us know what your questions are in the comment section. Make sure you hit the like button and subscribe to our page. Please make sure you hit the like button. I think I forgot to say that in the beginning. So that's all we got. Till next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast, with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.